Hello students, this is exercise number 23 of the Progressive Monthly Magazine, August 2021, on the speed of 100 words per minute. Start. First and foremost, it is pertinent to note that this court in its judgment in Saeed Abdul Qadir's case recognized that the issue of recovery revolved on the action being iniquitous. Dealing with the subject of the action being iniquitous, it was sought to be concluded that when the excess unauthorized payment is detected within a short period of time, it would be open for the employer to recover the same. Conversely, if the payment had been made for a long duration of time, it would be iniquitous to make any recovery. Interference because an action is iniquitous must really be perceived as interference because the action is arbitrary. All arbitrary actions are truly actions in violation of Article 14 of the Constitution of India. The logic of the action in the instant situation is iniquitous or arbitrary or violative of Article 14 of the Constitution of India because it would be almost impossible for an employee to bear the financial burden of a refund of payment received wrongfully for a long span of time. It is apparent that a government employee is primarily dependent on his wages, and if a deduction is to be made from his or her wages, it should not be a deduction which would make it difficult for the employee to provide for the needs of his family. Besides food, clothing, and shelter, an employee has to cater not only to the education needs of those dependent upon him, but also their medical requirements and a variety of sundry expenses. Based on the above consideration, we are of the view that if the mistake of making a wrongful payment is detected within 5 years, it would be open to the employer to recover the same. However, if the payment is made for a period in excess of 5 years, even though it would be open to the employer to correct the mistake, it would be extremely iniquitous and arbitrary to seek a refund of the payments mistakenly made to the employee. In this context, reference may also be made to the decision rendered by this court in Shyam Babu Verma versus Union of India SCC 521, wherein this court observed as under: we have held that the petitioners were entitled only in terms of the recommendations of the Third Pay Commission with effect from January 1, 1973. Accordingly, we direct that no steps should be taken to recover or to adjust any excess amount paid to the petitioners due to the fault of the respondents, the petitioners being in no way responsible for the same. It is apparent that in Shyam Babu Verma's case, the higher pay scale commenced to be paid erroneously in 1973. The same was sought to be recovered in 1984, that is, after a period of 11 years. In the aforesaid circumstances, this court felt that the recovery after several years of the implementation of the pay scale would not be just and proper. We therefore hereby hold recovery of excess payments discovered after 5 years would be iniquitous and arbitrary, and as such violative of Article 14 of the Constitution of India. Examining a similar proposition, this court in Colonel B.J. Akara versus Government of India observed as under: such relief, restraining back recovery of excess payment, is granted by courts not because of any right in the employees, but in equity, in exercise of judicial discretion to relieve the employees from the hardship that will be caused if the recovery is implemented. A government servant, particularly one in the lower rungs of service, would spend whatever emoluments he receives for the upkeep of his family. If he receives an excess payment for a long period, he would spend it, genuinely believing that he is entitled to it, as any subsequent action to recover the excess payment will cause undue hardship to him. Relief is granted in that behalf. But where the employee had knowledge that the payment received was in excess of what was due or wrongly paid, or where the error is detected or corrected within a short time of wrong payment, courts will not grant relief against recovery. The matter being in the realm of judicial discretion, courts may, on the facts and circumstances of any particular case, refusal to grant such relief against recovery. A perusal of the aforesaid observations made by this court in Colonel B.J. Akara's case reveals a reiteration of the legal position recorded in the earlier judgments rendered by this court, inasmuch as it was again affirmed that the right to recover would be sustainable so long as the same was not iniquitous or arbitrary. In the observation extracted above, this court also recorded that recovery from employees in lower rung of service would result in extreme hardship to them. The apparent explanation for the aforesaid conclusion is that employees in lower rung of service would spend their entire earnings in the upkeep and welfare of their family, and if such excess payment is allowed to be recovered from them, it would cause them hardship.